And thank you, Brooke. Brooke is an amazing resource for us as well, Alzheimer's services. I mean, you stick in my heart because one day I was meeting with a gentleman, his wife had dementia and he had held it all inside. He hadn't told anybody, he was trying to protect her and it was quite advanced and she'd even been getting violent with him. He was being hurt. And I called Brooke and she immediately said, I'm in a Zoom meeting, let me in this meeting. And I was able to put her on the phone. And that was like the first outreach that this gentleman had had. And it was so valuable. So thank you for all that you guys do over there. Y'all are great. I didn't really make a PowerPoint or anything. I want this to be kind of conversational. However, I am going to share my notes with Brooke and she'll be able to email them to you guys. So I don't want to get too technical, but there may be some words that you've never heard before or some things that you want to have defined. So I'll share that. I got to clean it up a little bit. I see a couple commas out of place and I had a former life as an editor, so I'll have to clean it up before I send it along. And I don't know what everybody's situation is, you know, sometimes it's a parent, sometimes it's a spouse, sometimes it's ourselves that you've gotten a diagnosis and you need to know what do we need to get in order. The good news is it's kind of the same answer to, no matter your relationship to the person that you might become a caregiver for, or if you're someone in need of care. The first question that people have is, what is my liability? Just by default of law, we have certain duties to each other. It depends on your relationship. Spouses owe a duty of care to each other. Parents and children also have a duty of care to each other. And then have you agreed to care for somebody? If you've agreed to care for someone, you need to follow through. If your situation changes and you find that you can't do it, you need to find someone who can, or report to the appropriate authority that you can no longer serve as the caregiver. We can't just leave somebody out there. And I think that's kind of obvious. Some people wonder, oh my gosh, could I get sued? Generally, the legal level of care is reasonable care. Did you do what a reasonable person would do under those circumstances? You know, did you know that your dad had dementia and still allow him to drive? Yeah, potentially there could be some liability, or if his condition had fallen to the point that you didn't realize, then, you know, maybe you wouldn't be held liable. But typically the people are held liable for their actions, not the caregivers, but the caregivers need to exercise reasonable care. So if you know your person is in a situation where they could harm somebody, you do want to get on top of that, just kind of out of a moral duty and potentially out of a legal duty. So to dive more into the rest of my presentation, the state looks at us as two parts. We are our persons and we are our property. So when you have someone facing a dementia diagnosis, and truthfully for any of us should have these documents in place. If something happens to me, I want someone to be able to step in and care for my person. That means making healthcare decisions for me, making decisions about if I needed nursing home care or not, where I would go, who would be in charge. And the other is my property, and that's access to the ability to sell real estate, access my bank accounts, pay bills, talk to my financial advisors, talk to my attorney, that kind of thing. Most concerns arise when we're looking at elder care for anything from access and control. So if you think of it like a bank account, access is the ability to write a check, but real control would be the ability to close an account and open a new one, or to liquidate somebody's stock account, to change the beneficiaries on a retirement plan. All of those things are really important. Access is pretty easily done. You know, the person, you can go to the bank with the person, they could put you on as a signer. But to get that actual control, you're going to want to do some powers of attorney, and I'm going to talk about that a little bit more. So how do we gain access and control? One is the consent of the person. So sometimes it can be oral, that yeah, I give you permission to talk to my doctor at the doctor's office. But more often, and what I want, particularly when someone has a dementia diagnosis, is a contract. And that contract, I mentioned it a minute ago, is called a power of attorney. The person who's executing that is called the principal. And if we're doing for that contract to be valid, that person has to know what they're doing, okay? They have to have capacity. Capacity is the ability to comprehend the purpose, the consequence, and the risks and benefits of a decision and any alternative. So I think some of us may not feel like we have capacity on an ordinary day. And that can be a little tricky for someone who just received a diagnosis or who's we think is on the cusp of getting an Alzheimer's or dementia diagnosis. But just because someone is there, that doesn't mean that we cannot execute the powers of attorney for them. You can't see it, but my law license is on the wall. I worked really hard for that. I'm not going to lose it for anybody. But please know that someone having an intellectual disability or a dementia starting to cook does not automatically disqualify them. I had one lady a daughter come with her mom in tow, and she was one of 6 kids. I was kind of automatically a little suspicious. And I pointed to the daughter and I said, "Who is this?" And the mom said, "That's me." I said, "Well, we're not off to a great start." So I chatted her up, tried to get her comfortable in my office. And a couple minutes later, I pointed to the daughter and I said, "Who's this?" And she said, "That's Pickles." And I said, and the daughter said, "Pickles was her cat. Her cat died a year ago. She just realized the cat's gone." Well, clearly that's somebody who has no idea of what's going on. I would not execute those documents for her. Those would not be valid. That said, I had another client. She kind of hit the point where she wasn't really talking anymore, but I was able to talk with her. Her husband had just passed away. And, I asked her a few questions and she was able to point. I said, "Where's your daughter?" And she pointed to her daughter. And I said, "Is it okay if your daughter can take you to the doctor and do your banking?" And she generally understood. And I asked her, I said, "Are you married?" And she did like this. She covered her eyes. She knew she was widowed. So capacity can change from day to day. If I execute these documents for somebody, they don't necessarily have to remember in a month that they signed these documents. But at the time of signing, they need to be signing of their own free will. We can't force them. And they need to have a general understanding of what they're signing. This is going to let your husband take you to the doctor and let your husband have control over your property, that kind of thing. So again, the three ways to gain access and control. The first one is consent of the principal. We do that in a power of attorney. The second one is kind of on an individual basis, and we might see this if you are someone's rep for Medicaid or Medicare, that there's a form with that agency that you and I believe the patient would fill out. So sometimes we do it piecemeal. We do it institution by institution. This particular doctor's office, you sign off and say, "Hey, I'm bringing my mom to the doctor," that kind of thing. The third way is kind of the hard way, but when we have to do it, we have to do it. And that's by court appointment. So for healthcare, there's a default of law. In the absence of a power of attorney, there is a list, a default of law of who can make medical decisions for somebody who's incapacitated. It's first their spouse. If their spouse, they don't have a spouse or their spouse can't serve, it's their adult children. And then it goes to other familial relationships, maybe their parents, their siblings. So a family member can make medical decisions. It's not as great as if we had that power of attorney in place, but it's something if there's an emergency or something happens or we didn't get those powers in place. So like I said, it can happen kind of piecemeal. And the third one is court appointment. And I'll talk about that a little bit more, but this is typically in the context of an interdiction. And that's a big deal. That's the nuclear option. We don't like it, but occasionally we have to use it. So I'm going to delve a little deeper into that power of attorney. All that is, it's a contract. It's a document that only works during a person's lifetime that enables someone else to make medical or property decisions for them and to consult with their legal, financial, and medical professionals. As I mentioned earlier, the state looks at us as 2 parts, right? We're our persons and we're our property. Some attorneys combine the powers of attorney into one. That's okay. I like to separate them out because you might have a different person managing your medical versus managing your finance. I always joke, my niece would handle my medical because she's really good with that. And a buddy from law school would manage my finances for me because she's really good at that. But I would never switch them up. My niece is terrible with money. And my friend from law school is a little rough around the edges. I don't know if that's who I want at my bedside if I'm in the hospital. And what happens at Our Lady of the Lake Hospital isn't really the business of what happens, at Chase Bank and vice versa. So my personal preference as an attorney is to separate them out, but it's not necessary. But I do want them to be broad, very, very broad. I want those people to have every power under the law to make decisions for somebody who is facing a dementia diagnosis. I mentioned capacity, and again, that's defined as the ability to comprehend what's going on, to understand the document you're signing, to be signing of your own free will. There's two relationships on this. The person granting the power is called the principal, and the person who's given the decision-making power is called an agent or a mandatory. In Louisiana, we have the law of mandate that says I can appoint someone to do something for me. So for instance, a year or two ago, I was going on vacation and I was selling a house. Well, of course, that closing is going to happen to coincide with my vacation. Realtor was a friend of mine. I was able to sign a document, and it was just for that one transaction, saying my realtor had the power to sit in that room and sign all the documents for me. So it can be that simple. It could be that situational. Typically, though, I want my clients to have very broad, very deep powers of attorney. Note that the power of attorney does not take self-determination away from the principal, but it grants authority to somebody else to help them. So if I have a power of attorney, that doesn't mean I can't make medical or financial decisions for myself. That just means I'm empowering somebody to help me make those decisions if I can't. You know, Karen could go to the bank for me. Brooke could make medical decisions if they were named in my documents. So just understand, it's important to understand what it is and what it isn't. Let's see, when we're talking about the financial power of attorney, which is typically called a durable power of attorney, they can be immediate, meaning as soon as you sign it, that document is in effect. So my buddy from law school is named Chantel. So the way mine's written, if Chantel had that document, she could go to the bank right now and do it for me. Some people are more comfortable putting something in there we call a spring, so they can be immediate or springing. The spring is typically, this is only effective upon my incapacity, because these are powerful documents. We take them very, very seriously. When I draft them, that person can sell your house out from under you. They can give your stuff away. They can take all your stuff and give it to themselves. Now, the trick is we want to appoint people that we trust into these positions of authority, but understand they are powerful. And so for some people, they don't want to give that power immediately, but they understand if they're aging or they've received a diagnosis that may debilitate them, that we do absolutely all want to provide for our own incapacity when we can't make decisions ourselves. As I mentioned, there are two main types. The durable power of attorney deals with your stuff, real estate, finance, insurance, investments, retirement, that kind of thing. Healthcare power of attorney addresses medical care. Both of these documents should appoint a curator and a guardian in the event that the principal loses the ability to care for him or herself. Again, this is kind of a rare occurrence, but I had a terrible case that I had to deal with in January. A lady had dementia. It had progressed. She was living with her husband. Her husband might be cooking some dementia himself, and the daughter had said, look, you're not taking care of mom. Something's got to give. Mom had powers of attorney appointing the daughter. That meant that the daughter could do her banking and everything else, but she had not appointed her daughter as her curator. And what that says is, if I can no longer care for myself, this is the person I want in charge of me. And it essentially wound up being a custody battle between the husband and the daughter. And it's something that's very ugly and it's very prolonged. But if that lady would have had good powers of attorney because they saw a lawyer when mom first got her diagnosis, but that lawyer had not put that particular clause in there. So it's really, really important. And again, kind of like with the healthcare, there's a default of law. Your spouse is the first person who would have the ability to be your guardian or your curator. Then it would be your adult children. But in this case, the husband wasn't really taking care of business. So it wound up being a fight, and it's still an ongoing issue. So we can prevent a lot of problems with those powers of attorney. Here's something else, and this tacks back into the liability. If you are signing papers for someone, if you are acting as their agent or their mandatory, please always sign agent or mandatory or attorney in fact after your name. I had a lady call me up crying because she was on the hook for nursing home care for her mom. She was acting in her mind under the power of attorney, but she signed that form in her own name. So the agent or the mandatory, they're acting on behalf of the principal, but they're not obligating themselves, because this lady didn't put that after her name. She had kind of put herself on the hook and owed a pretty large bill to the nursing home. Now I had to send her to another attorney to fight that because I don't do a lot of litigation, but just understand if you are acting as somebody's agent, let's always remember to put agent or attorney in fact after our names to kind of keep that liability off, to make that relationship clear. And we have a whole section of law in Louisiana called the law of mandate. So moving on, another document that all of us should have, particularly someone who's facing a diagnosis that's going to, see them decline, is a living will. It's also called an advance directive in some states. And it's a document that just states whether or not a person facing a life-limiting condition, which is usually terminal illness, comatose and not expected to wake up, or a persistent vegetative state, and they're physically unable to eat or drink, would they like to be given nutrition and hydration via an IV or a PEG tube? There's no right or wrong answers. It's just whatever your personal beliefs are. The vast majority of my clients say that they would not want to be kept alive under those situations. This is so relevant for folks facing a dementia diagnosis, because we might hit that point where we're very likely to hit that point where we can't physically eat. Would you want your caregivers to just let you pass? Or would you want your life to be prolonged with that feeding tube? And again, it's very personal. The majority of my folks say no, but sometimes I have people who, either for religious reasons or just holding out hope that there might be a cure, or they just value their life and whatever that looks like. No right or wrong answer, but if we can get that down on paper, it can cut out a lot of fights. I had a client come in the other day. Older gentleman, well into his 90s, perfectly fine. He still drives. Poor little thing can't hear. He's deaf as a post, but he came in with his daughter. His daughter has some very strong religious beliefs, and her father-in-law was in this situation, and the family she married into shares her religious beliefs. Her father-in-law developed dementia. He was kept alive with a feeding tube for about 2 years. My client said, I don't want to wind up like Mr. Jones. That was his specific request. He saw what happened in his daughter's family, said, I don't want to wind up like that. The daughter kind of had a little fit, and she said, well, oh, that was so beautiful, the way we cared for my father-in-law. And again, both of those are valid opinions. It is not up to me to judge, but I had to do what my client wanted. And against his daughter's objections, my client wanted that living will that said, I do not want to be kept alive with a feeding tube. So it's just something to have some conversations about, do some soul searching, talk to your family, talk to your minister, whatever you feel, but that's an important document to have. We don't see that, fortunately, too often, but it can be really important. What some people confuse with a living will is a DNR, which is a do not resuscitate order. You will not find a DNR in somebody's estate plan. As an attorney, I do not do a DNR. A DNR is a doctor's order. Just like if I needed surgery, or Karen needed blood work, or Brooke needed an MRI, right? We put that doctor's order in the medical file. So a do not resuscitate order, it has to be signed by the doctor and the patient, or the patient's representative, that says we're not going to revive you. If your heart stops beating or your lungs stop breathing, we're not going to do CPR. We're not going to pull out the little shocky paddles. We're going to let you pass. As you can imagine, that's usually only done for very sick people. I had a personal experience with it. My mom is 92 and thankfully doing okay. She still lives alone. But she had a fall during the pandemic, and we had to admit her to the hospital. And they asked her, are you full code? The opposite of DNR is full code, where we're going to take extraordinary measures. And I've never been on that side of it. And it was just so uncomfortable. And they're actually asking me and my mom, if something happens to her, are we reviving her? And my mom's like, well, I think so. And she looked at me and I said, well, yeah, there's nothing underlying wrong with you. You don't have any terminal condition. You're wide awake. Your mind is still good. But understand, once we hit a certain age, sometimes the medical professionals look at you a little differently. On the other side of it, I lost a sister to lung disease, and we knew that her condition was terminal. And the doctor had that conversation with her and said, look, you have this infection I'm trying to pull you through, but I would like you to give me permission to not revive you if something happened. And she was tired of fighting and she only had a little bit of time left. So she agreed. So that went into her file. The way this ties in with the healthcare power of attorney, my sister was able to answer that question for herself. Her doctor had that conversation with her. But let's say she was unconscious or she couldn't make reasoned decisions. Then the doctor would have had that conversation with her husband to say, do we put a DNR on the file? But just understand that the living will and the DNR are very different. The do not resuscitate is immediate. I'm not going to do CPR. I'm not going to pull out the little shocky paddles. Where the living will is, am I going to sustain you past the point when you're physically unable to orally take in food and water? And just to avoid a little bit of confusion, there are people walking among us every day, children, adults, elderly people who live just fine quality of life with a feeding tube. But this is that situation where you physically become unable to eat, and we don't expect that you have a very life-limiting condition, that we are terminally ill, or we just know you're not going to improve. So I just always like to put that out there. It's not a big deal, but I talk to people and they have a little confusion on that matter. Okay, here's the big one, interdiction. I touched on it a little earlier. So this is a legal process by which the state strips a person of their right to make decisions for themselves and appoints another individual to take care of that person. A person can be a full interdict, where they lose the ability to manage both their person and their property, or you can be a partial interdict, where you lose either the ability to take care of yourself or the ability to take care of your property. The case that we're all familiar with is Britney Spears, and that seems ridiculous. She was young and vibrant, but her father petitioned the court and was awarded custody of her and her stuff. He was in control of her money and he controlled her. He wouldn't let her marry. He made sure she was on birth control. So that seems that's typically not the context in which we would see it. We typically do think about this in terms of a senior, an elderly person, somebody with dementia, perhaps a child with a disability, but that's a real world example. So a person placed in charge of an interdict person is typically called their curator. Oh, wait, I got that backwards. Let's see. I'm sorry, it's backwards in my notes. So person in charge of somebody else's person is typically called their guardian or their curator. And somebody who's in charge of somebody's money and their property is typically called a conservator, although we might also use the word curator. It's a lawsuit and it requires a court hearing. It requires appearances by the relevant parties. We have to serve that person, where the sheriff knocks on the door and says, hey, you're being sued. The ones of these that I've done, I mean, the person had no idea. One was a disabled man. He was a quadriplegic. He couldn't talk. He couldn't eat. So it was basically the sheriff deputy just putting that in his lap. He wouldn't have known what that was, but that is a requirement of the law. So we take that very seriously in this society. Thankfully, we don't take people's rights away very easily, but that is shutting that person down. They've lost the ability to make decisions for themselves, and they have had a guardian or curator appointed for them. Again, I don't see that too often. When that typically happens, the dementia has really progressed. I tried to do powers of attorney with a lady. I went to visit her, and she was having a conversation, and there were about 3 people in the conversation, but they were all inside her head. So there's no way that I could explain, hi, I'm a lawyer. Hi, I brought some paperwork. Hi, is it okay if your daughter takes you to the doctor and does your banking? I mean, she was just so far past that. We had to do an interdiction, and we have to do it. We have to do it. Again, it's not my preference that we should all have those powers of attorney. Anybody age 18 or older should at least have powers of attorney in place, because none of us is guaranteed a tomorrow. None of us is guaranteed a healthy tomorrow. But again, super critical for our folks who've received some kind of debilitating diagnosis. So the next, are there any questions? I feel like I'm just like talking. Do we have any questions? If anybody wants to unmute and ask a couple of questions.
Yeah, if everybody can just put their questions in the chat box.
Okay.
We don't have it where anybody participants can unmute, but if y'all want to put some questions in the chat box, I'm happy to read those out for you. Miss Paula, this is so good so far. I'm just
good.
All of your examples are so good.
Awesome.
I see some people maybe type in.
Okay.
So we can hang tight just a minute or two.
Absolutely.
While we wait, Ms. Paula, maybe if you could talk to us about the different types of people that can do a power of attorney. Who do we go to do a power of attorney? Is it a notary? Is it?
Oh, that's a good question.
Your neighbor, Sam.
So typically it at least needs to be a notary. These documents need to be that Louisiana, we're real picky about the form for things. So like I said, this is a contract. This is a contract saying, you know, my healthcare power of attorney is a contract saying my niece Erica has the power to act for me. So attorneys do them and notaries do them. My only caution with that is I want the finance one, the property one, to be very, very broad. And in Louisiana, there are a few things that need to be specifically spelled out. Okay, the ability to sell real estate, the ability to take someone's property and give it to yourself. And that may sound a little bit weird, but in the context of Medicaid planning, sometimes I do need to be able to take somebody's stuff away from them and give it to somebody else. So either an attorney or a notary can do that. Mine are executed before a notary and 2 witnesses. Every attorney in Louisiana is a notary. Well, if you register with the Secretary of State, every attorney in Louisiana should be a notary. So those are the 2 main places that you can go. And look, I will never, ever knock the work of notaries. I have a cousin who's a notary and I call her sometimes for legal advice because she's been doing it for so long. But mine are about 12 pages long. So just know I enumerate all the powers that person has. Okay. So, okay, let's see. I have a message from a question from Michael in reference to the lady who failed to sign her name correctly. I was unclear on that part. How does signing with an agent after the name change it? And why was the person who failed to do so held liable? That's a really good question. So one, I think the nursing home was kind of jerking her chain a little bit and just wanting to get paid. But you want to make that relationship clear. In that particular document, it was who is responsible for paying for this. So if she would have put agent after her name, it would have been clear that she's acting as the agent for her mom. She's standing in mom's shoes, but she was not personally obligating herself. So that was just a real world example that really got my attention. So because when she signed as being the person who's liable, kind of like when you go to the doctor, if you're taking your kid to the doctor, who's a responsible party? Obviously, we're not the agent for our kids. And if I take my son to the doctor, I'm responsible for paying his bills because he's 11. I'm not responsible for paying my 92-year-old mom's bills. So I just want to make it very clear that I'm acting as her agent, that I am not personally accepting responsibility. I hope that answered your question. Is it best to, the next question, is it best to get these documents typed or can it be handwritten? Does it make a difference? In a pinch, a handwritten one, I guess, would do. I would absolutely recommend you at least go see a notary, if not an estate attorney, to get these done because they can be very tricky. In a pinch, you know, yeah, but and it's a little different with a will that I'm about to talk about in a minute. But for powers of attorney, I think it would be better. And then you want to get it signed before a notary and 2 witnesses. And Louisiana gets a little weird, a little picky about our documents for better or worse. So I think it would better to be typed, and better, at least if money's an issue, go see a notary at the bare minimum and let them know you need something very, very broad. Okay, anybody else? Okay, so I'm going to scoot on and kind of shift gears a little bit. Those are kind of the things that would happen during a person's lifetime. Next, I'm going to talk about the estate because that's a concern that people have sometimes. What's happening? What's going to happen to my stuff? What's going to happen to my parents' estate? So all your estate is quite simply your stuff. Estates are broadly divided into 2 categories. There's something called probatable assets, and those are assets that are either going to pass by a last will and testament or by default of Louisiana law. in the absence of a will. Examples of that include like real estate, bank accounts, CDs, jewelry, vehicles, investment accounts. I've had clients with gold bars, furniture, stocks and bonds, that kind of thing, the stuff that you own. The other broad type of asset is non-probatable assets. And those are things that typically pass by named beneficiary. That would be usually an IRA or 401k, life insurance, and annuities. Non-probatable assets can become part of the probatable asset if the owner fails to name a beneficiary or if they name their estate as the beneficiary. So in a will, with some exceptions, you can leave your stuff to whoever you want. If you die without a will, the default of law takes over. Louisiana law, I always joke, assets like poop roll downhill. Okay, so it's going to go to your children if you have children. If you don't have children, certain assets would go to your spouse. If you don't have a spouse or children, assets are going to go to your siblings. If you don't have siblings, it's going to go to your parents. So for some people, that's fine. For some people, the default of law is A-okay. Some people, they don't want to do that, or some people, they need to put a little more control. So for instance, I have an 11-year-old son. And I joke, I worry about this child's relationship with money because he's so tight he squeaks. I actually had to ask him the other day, I said, do you think we're poor? Because he's just so reluctant to spend money. But for an 11-year-old, I'm not just going to leave his inheritance outright. So in my will, I have rules for how he would receive his stuff. That's the beauty of doing a will. You can say where it goes. Now, there's two concerns when we're talking about wills when we're dealing with somebody with dementia, okay? If the person with dementia needs to make a will, we're going to tread really carefully, right? Because we need to make sure that that person has capacity. We don't want that will to be challenged later. There are a few ways, only a few ways to challenge a will in Louisiana. Form, was it signed before a notary and 2 witnesses, or was it done in the proper form as an holographic will, which I'll talk about in a second. Was the person coerced? Did I say, Mom, you better sign this will, leaving everything to me, or I'm not taking you to the doctor anymore, or hey, I'm not going to be your friend. Or fraud or duress or undue influence, or the form. Okay, so the person has to knowingly sign, and they have to sign of their own free will. Again, I don't, if somebody still has capacity to make a will, that's great. That's not always my highest priority though, but it is something to consider. And then this is kind of terrible because you kind of want to watch the access to the person, because somebody could come in there with it, if they get a notary to go in there and change things around, that could make a mess. So if we have somebody we're caring for, we want to kind of protect them as much as we can. If I hate to say it, if we have some kind of cousin or sibling or somebody we don't trust, you might want to do what you can to limit that person's access. Because I've seen, fortunately not too many in my practice, but occasionally I'll get a client who's like, I know my dad did not change that will. Look, his dementia, he got diagnosed 2 years ago. His dementia was really bad. My cousin is shisty. They sneaked into the nursing home and did this. So, you know, it's better to prevent it. The other thing, when somebody passes, we do something called succession or probate. Louisiana, we use the word succession. Other states tend to use the word probate. They mean the same thing. It's the legal process of administering a deceased person's estate. So as I mentioned, a person either dies testate, which means they have a last will and testament, or they die intestate, where they don't have a will and the estate gets directed according to Louisiana law. For intestate successions that are valued at less than $125,000, or that have a will that aligns with the laws of intestacy, you can settle the estate with an affidavit of small succession. It's a sworn statement signed by the spouse and the children saying, yep, this is what they owned, this is who it belongs to, we're all in an agreement, and then the assets can be distributed accordingly. Otherwise, it requires judicial approval, and it's a formal succession. We have to go before the court. We have to provide the court with certain information. Who was this person? Where did they live? Where did they die? What did they own? What did they own? Who was their family? Where's the stuff supposed to go? And at the end, you get something called a judgment of possession, and that lets the appropriate people go, go to Chase Bank and collect something. I had one today that just recorded that judgment of possession to transfer ownership of a house to the gentleman's son. Let's see, I'm going to take a peek in the questions. Let's see. Okay, Michael, I'm going to ask your last question. Oh, let's see. Oh, we had a few pop up. I'm sorry. Let's see. We're bouncing back a little bit, but that's okay. Does obtaining a durable power of attorney change financial responsibility if a nursing home is needed? The statement was made that the agent can control finances and move them into their possession. So I was wondering if the state is limited in their pursuit for recovering funding when nursing home costs when a POA is introduced. So I'm going to touch on the Medicaid in a little while. Let me break that question up into pieces. So does obtaining a durable POA change financial responsibility if a nursing home was needed? Like I said, that lady, I didn't want her signing in her own capacity. I wanted her signing as the agent. When you're getting into Medicaid paying for a nursing home, there's a 5-year look back. So you can't have given anything away of value for the last 5 years. So even if you're self-dealing, that can impact that. Let's see. So, and when we're doing Medicaid, there's 2 parts. There's getting somebody qualified for Medicaid, and there's preventing recovery when that person dies. So you want to use those POAs. When I do Medicaid planning, I always bring in an expert to help me with that, to help me position the assets. That's kind of jumping ahead a little bit. Karen asked, can I touch on usufruct briefly? Yes, I can. So there are 3 qualities of ownership of property. There's the use. Well, in Latin, it's usus, fructus, and abusus. In English, it's the use, the fruits, and basically the abuse. Or naked ownership is what we commonly call it. So if somebody can use something, think of it like a house. If it's a house, I can live in it. I could rent it out and keep the rent. And the naked ownership would give me the ability to do something drastic to it. I could burn it down. I could make major renovations. I could refinance it, that kind of thing. So by default of law, if somebody is married and has a spouse and children, the community property, if the home was owned 50-50 by both spouses, and one spouse dies, the surviving spouse retains his or her interest in it, but they also get control over the other spouse's half, but they only get the use and the fruits. So they can't sell it, they can't make major renovations, they can't refinance it without the naked owner's approval. So in that example, if that person had children, then the surviving spouse, if they wanted to do anything to that house, they would have to get the permission of the children if they were going to do anything drastic, sell it, get a new mortgage on it, that kind of thing. And then let's see, Michael, going back to Michael's question. Let's see. So Michael, if I'm understanding your question correctly, I'm assuming that's on your parent that you have the durable and the medical POA. It says when your dad was dying with cancer and they wrote the power of attorney documents, they did a will with the hopes to protect his mother and wrote the will for her to receive everything. That's not necessarily always the best way to do that. And I guess now is as good a time of any to touch on that. When we have a married couple, it can be pretty easy to get somebody qualified for Medicaid. I had a gentleman earlier this year, he knew he was terminal, and we wrote his will that he was not leaving to his spouse directly because mom was pretty old, and it was kind of a tool. I could very easily get rid of half of the estate. It's there for mom's use and benefit because we put it into a little testamentary trust, but she doesn't own it. So I'd be happy to kind of take that up with you a little bit more. If you wanted a one-on-one, I can give you a no cost, no obligation consult on that to kind of go into that. But sometimes we want to leave it to the surviving spouse. Sometimes we don't. Sometimes we want to leave it for their benefit, but sometimes we don't want to leave it to them directly, particularly if it's a really elderly couple, because if that the surviving spouse eventually needs care, we don't want them to have any assets. So we want to, it's a balancing act because I want my surviving spouse to have everything they need. Yeah, I appreciate that, Michael. Yeah, let's chat another time. But sometimes you do want to take care of the well spouse. Sometimes we want to take assets away and start repositioning with an eye toward Medicaid planning. Okay, so I'm sorry, we took a little derailment there. So going back to succession and probate. Like I said, sometimes we need to do a full probate. Sometimes we can just do it by affidavit if it was a smaller estate as defined by law. Last will and testament is just a letter into the future in which a testator outlines who will receive his or her property after death. And it typically appoints an executor who's going to be in charge of managing the estate, paying the debts, taking care of probate, and ultimately distributing the assets. There are two main types. So somebody had asked me about handwriting. So there are two types, and Louisiana is very picky on how you do it. The first one is called an holographic testament. It has to be entirely signed, written, and dated in the testator's own handwriting. So if you print off one of those forms off the internet and it's typed up and you sign it, that's not going to be a valid holographic will. It has to be entirely handwritten, okay, in the person's own handwriting. And we can only have one person. You can't have a married couple and the wife pulls it out and says, this is our last will and testament. Each spouse has to be entirely signed, written, and dated in their own handwriting. And it needs to say something about, this is my last will and testament, okay? It has to have donative intent. The other type is a notarial testament. Those are typically typed. The person has to sign the bottom of every page, and they have to do it in the presence of a notary and two witnesses. And it requires some attestation language. This person came and appeared before me and said this was their last will and testament, and you sign. As I mentioned a couple times already, if a person dies without a will, his or her stuff will pass according to state law, which gives community property to the children with usufruct to the surviving spouse until their death or remarriage, and it gives separate property to the children directly. So we want to think about that. If I get married to somebody and we're living in my house, and I die without a will, my spouse, if they don't own that house, my heirs could potentially come and kick that person out. And I incorrectly used the term heir just now. So that was my next point, heir versus legatee. An heir is somebody who inherits property from a deceased person by default of law, while a legatee is the recipient of an estate whose assets are named in a last will and testament. So it's just, we give you a fancy term if you have a will. I touched on a minute ago, a trust. All a trust is a contract that defines your relationship with your stuff. The main types that I use in my work are living trust, testamentary trust, and special needs trust. So there are three parties to every trust. There's a settlor, there's a beneficiary, and there's a trustee. The settlor is the person who establishes the trust and writes the rules for how the assets are managed and distributed. The beneficiary is the person who gets to use and enjoy the assets that are placed into the trust. And the trustee is the person or entity who manages the assets. So think of a trust like a box, and I'm writing some rules on the outside of the box. And I put the things inside the trust that I want to be managed, okay? I'm the settlor. I've created the box and written the rules. The beneficiary is who gets the stuff that's inside the box, and the trustee is a hand that manages the stuff and can reach in and take something out and give it to the beneficiary. Living trusts are set up while the settlor is still alive, and they hold assets until the settlor's death. These avoid the probate process. That's a big boon for some people, is avoiding probate. And then the assets for the next generation could also be placed in trust. So you can write a trust for how the people receive after your trust goes away. The other one is a testamentary trust. It's called that because it's a clause in the last will and testament. It states how a legatee will receive his or her inheritance. They're highly recommended for parents of minor children, anyone whose legatees may need help managing their inheritance due to mental or emotional problems, drug or alcohol addiction, undue influence of other people, poor money management skills, or if they have existing debt or judgment against them. So my personal plan, I have a testamentary trust. I have rules for how my 11-year-old son is going to receive, and I have a trusted adult who will manage his inheritance from me. The cool thing about that too is I can also name his trust as a beneficiary my life insurance. My particular company won't let me name an 11-year-old, and I'm worth more dead than alive. That's a big asset. So in my assets that are going to pass by named beneficiary, I have named the testamentary trust for the benefit of PJ to receive. So I know that that's going to be managed the way I need it to be. Let's see. And then the special needs trust. So we think of this, perhaps we have a spouse who does have dementia or some other kind of debilitating condition. We can leave on their behalf, but it doesn't count as an asset for them. So if we're thinking about getting them qualified for benefits, that's awesome, because that money can be used for their care and their support, but it doesn't count as an asset. So we can make them poor on paper so that they would qualify for Medicaid. Sometimes we have a child or a sibling with a disability. And same thing, it can be used to provide for that person. We put a trusted adult or an entity in charge of that, whatever that asset may be. And it's there for their benefit, but they don't ever own it. Very briefly, paying for a nursing home, because that's a huge concern, because if we have somebody with dementia, that's a long road that we're embarking on. And it's very likely we're not going to be able to keep that person at home for the duration of their illness. You have three options when it comes to nursing home care. You have private pay, you can have long-term care insurance, or you can have Medicaid or some combination thereof. Very briefly, I think most of us know this, Medicare versus Medicaid. Those are two U.S. government programs that are designed to provide health care. Medicare is an entitlement program, and Medicaid is for economically disadvantaged people. So for most of us, you know, there's that Medicare chunk that's taken out of our every paycheck that goes to the government with the hope and understanding that one day if we need medical care, the government's going to pay for us. Medicaid is for poor people. There are asset and income limits on that. Medicare will only cover about 3 months of skilled nursing. It's usually for rehabilitation. If I've had a stroke, if I've broken a hip, and I need skilled nursing for a finite amount of time. I think they pay for like 90 or 100 days. Karen may know better than I do.
Yes,
That's temporary. But if I'm going in the nursing home because I have dementia, chances are that's where I'm going to live out the rest of my days. Medicare does not pay for that. We've got to get you qualified for Medicaid. And what the two concerns we have with Medicaid are getting you qualified and preventing recovery after the person passes away. So we could talk about that a little bit more, but that's just kind of a basic overview of that. So, and in closing, I have two questions. Are your loved ones' affairs in order? If they still have capacity, I want you to go see a notary or an attorney ASAP and at least get powers of attorney in place where that person can say, if I can't take care of myself anymore, this is who I want in charge. This is who I want to be able to make my healthcare decisions if I can't make them for myself. And this is who I want managing my money, my property, my retirement assets. And the other question, since we don't have enough on our minds, is, are your affairs in order? We should all have our own affairs in order. Sometimes with my senior couples, it breaks my heart, but sometimes the well spouse passes away before the sick spouse. And that can cause a whole mess because you got to take care of yourself. You know, the old adage about, you know, if you're on the plane and the oxygen mask falls, put it on yourself before you put it on other people. Have you taken care of yourself? And sometimes we do want to direct those assets where if something happens to the well spouse first, it's not going to the ailing spouse because we don't want it to get scooped. We don't want to disqualify that person for Medicaid. And those are kind of discussions are a little bit more in depth. I would encourage you to, you know, talk to a lawyer, talk to somebody else about that, but that's just kind of touching on the basics. Are there any other questions? So Michael just asked, are wills filed at the court? Eventually they are. We do not file them ahead of time. That was practiced a while back, and I believe the Secretary of State maintains a registry of wills. I do not file my wills. However, when somebody dies and it's time to do the succession, the court wants the original will. So those original wills are very, very important because the idea I can cancel my will by writing a new will and saying all prior wills are valid, or I could go grab it and tear that will up and then I would die intestate. So wills are not automatically recorded. It used to be a practice to record them before the person died, but they do have to be given to the court when we're starting that succession and probate process. Anybody else? I feel like that was a lot of information to throw at you, but just the, you know, basic liability, basic documents. Again, the one takeaway, please, please, please get powers of attorney for yourself. And if your loved one is capable, please get powers of attorney for them. Otherwise, you might have to do it piecemeal, or if you just find you're hitting brick walls, you may have to go through that interdiction. And I don't mean to make that sound so awful. I've been scarred by my experiences in practice this year, especially with the one where it became a custody battle. That was one of the worst things I've ever professionally experienced. And I broke a rule of lawyering. I took it personally. We're not supposed to, but I just couldn't help taking that one personally, because I knew I was on the right side, because Daddy wasn't doing what he was supposed to do. Let's see. I think that's it. Miss Karen, did you have any questions for me?
No, I think for me, my thing was just the use of Rex, and I will definitely be reaching out to you because I have a godmother who adopted me when my parents passed away,
Mhm.
and Lord help me, this lady will not get these things together.
Right. Now, so she legally adopted you?
So I think it's called like guardianship. So she's actually my mother's oldest sister. And my parents passed away when I was 16. So there is guardianship papers. But her husband passed away over 10 years ago. Her son recently passed away, and then she has another son who's battling cancer at this time.
Oh,
So
God.
I'm trying to get both of them on speed. So I did tell her that I was speaking with you or listening to you today. So hopefully I can spread some of this stuff. So, but no, ma'am, I definitely would like to meet with you in private for some advice on how to proceed.
Okay, and just a little interesting bit of trivia, adopted children, that's why I asked if there was a legal adoption, because adopted children have the same rights as biological children. And if someone, I know your parents passed, but someone who's been given up for adoption, they can still have rights to their birth parents' estate as well, and their adopted parents' estate. And then let's see, I saw somebody sneaked another question in there. Somebody said, what if there is no succession? Let me hang my head in shame, Michael, because you've heard the saying, the cobbler's children have no shoes. Well, the estate planning attorney's family does not get legal services. August was the 10th anniversary of my father's passing. He had a will. The will left everything to my mother. Guess who still hasn't completed her father's succession? I do not encourage you to wait 10 years. It was not critical because my mother had access and control, right? Her name was on the bank accounts. All the benefits were coming to her. It was not a problem. But let me tell you why we need to do it. One, mom's getting a little long in the tooth. She's 92. She's like, you know, I'm not going to live forever. Are you going to take care of this or not? And she wants to sell property. So there's a piece of land that she and my father co-owned. She cannot sell that until I do the succession. She's got the use and the fruits, but we've got to go to court to get the naked ownership recognized for her. So if there's no succession, I just talked to a little lady who was recently widowed. I don't know the circumstances, and she's all in a tizzy. I said, look, do you have access to the bank accounts? Can you take care of business? And she said, yes. I said, look, just take a couple weeks. I can finish grieving, do what you got to do. I'm not worried about you. If you have access and control of the assets, that's okay. But let me tell you why you do need to eventually do a succession, because this stuff fractures. Remember, assets like poop roll downhill. So where it was one person, well, if that person dies, then they have kids, and then their kids have kids. So when somebody dies, they don't get cut out of the loop. Their share fractures to their children. So what could have been two people 20, 40, 50 years ago, you know, could be 25 people today. So it's not good to let those estates linger, because nobody loses their rights just because they pass. You know, my mom had 6 kids. There are only 2 of us living. My mom has outlived 4 of her 6 children. But if she didn't have a will, my brothers and sisters who passed, they're not cut out. But what happens is my nieces and nephews from those children, from those siblings, will inherit. So when you do finally have a piece of property you have to sell, you have to go and track down all these people, and it can be a real nightmare. So I don't encourage people, it doesn't have to be the first thing you do that somebody passed away, you call the attorney, you know, grieve, take care of what you have to take care of. But you do want to get that going within a reasonable amount of time, particularly if there's real estate, because those rights don't stop coming. It just keeps rolling. And I'll hit cases. I hate them. I hate them. I hate them. Where, okay, somebody wants to sell a piece of property, but now I have to go back and do 3 other successions because these people died without taking care of business. So I hope that answers your questions. And with that, I think it's time to pass to Miss Karen. Is everybody doing okay out there?
I believe so. Oh, yep. I think
Take it away, Miss Karen. Thank you so much, Paula.
Thank you so much, Ms. Paula. It was a lot of information, but definitely needed information. I have all kind of notes on my notes.
Cool.
So I was too excited to be asked to speak with you. So my point of view is just going to be like how to start those conversations. So it's kind of a little bit before you would reach out to Ms. Paula, or a little bit before Ms. Paula comes into play, and just like things to consider. Most of you may already have these things put in place. Like I think Mr. Michael may have had those things already put in place, being power of attorney and stuff like that. So I just want to kind of introduce like what to consider, what to look at, what to look for. And I'm gonna try not to overlap what Ms. Paula was saying. So, but I do want to kind of consider the factors. So when Ms. Brooke came to me about just kind of speaking, I always put myself in the predicament about what would I want, or what would I want to talk about, or what would I want to hear about, like what to consider. So of course, my first thing is how to start the conversation with your family about the legal preparations. Like, how do I start this process? Because some people, like myself, I had nowhere to start. Like I just said, my godmother is 76. She is stuck in her ways. I've been trying to do this since my brother passed away 3 years ago. Hopefully I can take the knowledge that Ms. Paula gave us today and kind of use that. So just a few things to consider. You definitely want to look at the lifestyle situation of your loved one. Like, what do they don't want to happen? Where do they want to live if they can't live for themselves? As working in palliative and hospice, we usually use what we see in front of us. So I usually say, hey, have you saw like a situation on TV on one of these ER shows, and is it something that you don't want? And that usually starts the conversation. But you want to kind of touch on what they want and what they don't want. And you'll find it interesting that they may already have certain plans in place. We just, as loved ones or children of that person, just may not know. And then of course, where would you want to live if you can't take care of yourself? Like, is the plan to come stay with me, or come stay with my older brother, or go into a facility? Like, what are those plans are, because I would need to know. Like I said, some people have these things in place years before. I know my experience as a palliative and hospice social worker. It's a lot of cases where we see the either husband or wife has passed away several years ago, 10, 15 years ago, and they made these plans that long ago, and the family just never talked about it until now we're in this hospice situation. So it's good to ask that question, because they may already have that plan put in place. And then of course, the legal aspect of things to consider, which Ms. Paula touched on in great deal. So I'm not going to really go into that, but like, do you have the living will, the durable power of attorney? And then just also making sure that those documents are up to date. Like, you know, some people fill out these documents years ago and things may have changed, or, you know, just seeing if they know where they are. Like, I have a patient who had hers in a safe deposit box, but she couldn't remember which one. So it's just about asking those questions to get the conversation kind of started. And of course, do you have long-term care in place? Some people have a long-term care policy, which is something you pay into, like life insurance. Are those things put in place? Because a long-term care policy can pay most, if not all, into a facility, versus us trying to find the finances. They may have paid into these policies that can cover most of the costs for assisted living or full-time nursing care. And then of course, you want to consider the finances. How do you want your finances to be managed if you can't? Do you have a list of your bills and how it's paid? I know my godmother used snail mail. If y'all don't know what that is, she literally sits down and writes a check for every single bill. She put a stamp on every single bill and she mails it out. She does not believe in auto pay. It is against the law for her. She does not like it, but just kind of asking those questions so you know. Also, who do you want to make those medical decisions if you can no longer care for yourself? That goes back to Ms. Paula and talking about those different documents, the living will, the post document, the power of attorney, and just kind of like the different scenarios she placed for us just a few moments ago. And then of course, what are your wishes, which she talked about CPR and DNR. I actually have one, if y'all have never seen one before, this is called a LaPoste document. I know it's not great, but you can Google LaPoste, L-A-P-O-S-T, or L-A-P-O-S-T, which is Louisiana Physician's Order for Scope of Treatment. It basically talks about resuscitation measures, either DNR or CPR, which is considered CPR as full code, DNR, or like I would say, allow your body to naturally pass away. And then it also talks about the different treatments that you can do with that. Of course, full code means you want everything done, all the bells and whistles. Even if you decide to do a DNR or do not resuscitate, there are certain interventions you can still do. So you can still get IV antibiotics, you can still get IV nutrition, all of that good jazz. But that particular document, you can have that filled out. It does not need to be notarized, but it does need to be signed by a doctor. And Ms. Brooks said they have documents available at Alzheimer's services on end-of-life planning, such as 5 Wishes. So 5 Wishes is another document as well. It kind of goes in detail about if you're in a coma, what do you want done? If you get in a car accident, what you want done? And that document is a state document as well. So you don't have to get it notarized. You just need 2 witnesses. I usually say do not use family. If there's someone you trust, have those people witness it and it's good to go. Make sure your family has it. So also other things to consider is care options. Where would you like to receive your care? Would you like to stay at home? Would you like to be in your facility? A lot of people are like, I want to, and I hate to be so graphic, but I want to die at home. This is my family home. My husband passed here. My wife passed here. Whatever. I want to die at home. And some people are like, I do not want to die at home. I want my family to remember my good times here and not that this was the last place I took my last breath. So you want to definitely ask those questions. I find that those kind of questions get the conversation started, but once again, you know your family. I'm just kind of giving you suggestions. And then who would you like to provide your care? Would you prefer a family member to provide your care? Would you like a sitter or a service to provide care? Would you like to have other services come in like home health or hospice or anything like that? And those are definitely based on your diagnoses, but just kind of questioning where you are. Our hospice program, we have seen patients deal with their terminal illness for several years before they decide to go with us. But when we do interfere, when we do come into play, they knew in the beginning that I wanted hospice if I couldn't do these measures, or if there was no other treatment, I wanted to enroll in hospice. So trying to find that out will be a great deal. When do you think it's appropriate to be moved out of your home? It may be a little bit difficult for our dementia and memory loss patients to make that decision. However, the earlier, the better. I do encourage, if your family member, or if you have a family member that was diagnosed with dementia and it was a very early diagnosis, try to get as much as that information done in a comfortable setting, but as quickly as you possibly can. You don't want to kind of come up with so many things at once to maybe agitate them, but time is of presence. So you definitely want to get those wishes while they can still make those directives as clear as they can. When do you think is appropriate to move out? Okay. And then also talking about the cost of long-term care. Basically, if the goal is to go into a facility, how are we going to pay for that? Do you have a long-term care plan in place? How much do you think that costs? I'll be honest, some of these facilities are very expensive. Some start at $5,000 up to $11,000, $12,000 per month. It is a lot of money. However, some of these long-term care plans may be able to offset that cost, and maybe your family member has that money put to the side to ensure that that's done. There are also some services in this area that provide 24-hour live-in care in the home, which runs about the same cost as a nursing home placement or a facility placement. It just depends on what you want. Some families want their patient to, or want their loved one to be at home. Others would prefer to kind of separate the role. They don't want to be the caregiver and the wife, or the caregiver and the daughter. They want to be the daughter, they want to be the wife. So going to a facility definitely helps. And then just touching on like what Ms. Paula was saying with the Medicare and the Medicaid. So Medicare does not cover the cost for custodial care, which is nursing home placement. It only helps cover like rehab, skilled care, and that's after a hospital stay. Just kind of FYI, I like to give everybody little tidbits of information. A person generally would qualify for skilled or rehab care if they're showing signs of weakness and if they have a 3-night stay at the hospital. Outside of that, they may send them home with home health or any other service, but Medicare does not cover the cost of nursing home placement. It's very critical to kind of plan ahead for those. I know this sounds really crazy for what I'm about to say, but some people can do that, others cannot. But it's preferred that you kind of have savings for about 5 years before care is needed. And then they can private pay. I was just speaking to a family about transitioning their loved one, and they have a lot of finances. So you talk about spending down that money. And then once you reach the Medicaid guidelines, which is $2,000 or less, you can apply for Medicaid, and then Medicaid will cover the cost, which will only leave your loved one with about $36 a month after Medicaid and their monthly income, if it's retirement or pension or anything like that. Also, other things to consider is, do they have VA benefits? Do they have savings? Of course, long-term care insurance. And then it came up with reverse mortgage. I don't know if some people know what that is, and I'm still kind of fuzzy on that. But reverse mortgage is where I think they pay you for the value of your home, but if you pass away, your family would have to repurchase that home for you to keep it, if I'm not mistaken. But those are questions to ask if you're thinking about being placed outside of the home. Any questions with that? Was that too much? If I talk too fast, y'all let me know. I'm a fast talker. All good? I don't see no questions.
Yep, I don't see any questions so far.
Okay, perfect. So things you need to know before you get started, like before you even try to sit down and have the conversation, I usually say arrange a time to talk in person. It's so much better to talk in person. I know with COVID and everything that's going on, we did a lot of FaceTime, a lot of Skype, Zoom. My son was saying something about Google Meets, whatever that is. But try to do it in person. And if not, use these streaming or face platforms to try to start the conversation. Be available. Allow as much time as necessary, just so you won't cut the conversation early, so we won't miss out anything important. Ask as many questions as you can, and also listen to the questions that are being asked to you. Be very respectful of your loved one's opinions, even if we don't agree what it is. I know for children, we want to be able to have our parents as long as possible, or our loved ones as long as possible, but they may have goals and wishes that may not align with what we think. And we need to be respectful of that, because at the end of the day, they're still our parents, and we want to be respectful of their wishes. Be very flexible. While it's helpful to have kind of an outline, the conversation may go in so many ways, and just allow it to flow. Just allow it to flow. This conversation may take multiple visits. I know I encourage a lot of families to do that, because I do a lot of advanced care planning with our palliative care department. And I always tell families, this conversation may take more than one visit. It may take multiple visits. I'm going to go with the flow of the family and the patient, and we're just going to go and see how it goes. keep the atmosphere light. Although we are talking about serious decisions, open up the opportunity to smile and laugh and joke, just to keep the atmosphere, light. Be very flexible, be prepared, and don't overwhelm your loved one with like a lot of forms, like you want to show them 15 million forms. I usually go with that one La Post document at first. If that's too cut and dry, I do talk about the 5 wishes because it talks about different scenarios and then kind of go from there. One crazy trick that I use, which I have no idea why it works, but it does. If I have a family that doesn't want to talk about their end of life wishes, I go all the way to the very end. Well, do you want to be buried or cremated? Oh, well, I want to be cremated. Okay, well, tell me about how can we get there? Do you have a funeral home in place? Do you have a policy? And kind of get back to the ultimate question, which is, okay, what do we want as far as your end of life goals? So sometimes you have to go way right to come back left, if that makes any sense. Don't come with a plan. Talk with your loved one to see if they have a plan or even if they have anything in place. They may have something in place, especially if this is our first time talking with them, like they may already have something and we just don't know. Allow your parents or your loved one to make their own choices. If their health or safety is a risk, then you may need to make decisions for them. However, even in those circumstances, if at all possible, you'll want to consider their input and choices. I've had several dementia patients that can tell me clearly what they want and do not want, and we want to honor those wishes. With complete clarity, they knew exactly what they wanted and what they did not want, and we have to honor that. In certain moments, they are very clear. Dementia to me is just like a light switch, but if you ask a question and if they're very clear and you can sense that they're at clarity, take that as what it is, and we need to make sure that's documented. That way we don't have to go through that again. I do have some options on how to start the conversation. Some are a little bit unorthodox, but I'm a little bit unorthodox, so bear with me. So one of the ways to start the conversation is just come straight out. Look, Mom, I would like to talk to you about your end of life goals. I would like to know what your wishes are so I know how to support you when or if that time comes. Some parents might be resistant to that, some not. I'm still working on it because my godmother is not having it. You can also start by asking them about their past, their childhood and their parents, or just what they've been through in their life. Listen to their stories and learn about what type of person they are. I feel like I've learned about my mother more now that she's deceased than I knew when she was alive. And I feel like I know my godmother more now listening to stories than I've ever learned before. Also talk about someone else's situation. So I keep referencing my grandmother, y'all, because I'm literally going through this situation. So please accept my apologies if I'm going too personal. But my godmother is it's called the mother of the church. So she's the matriarch of the church. I think like the oldest standing member of the church. So she's at every funeral, every program. So one of the suggestions that I've tried, and it kind of worked a little bit, is to talk about someone else's situation and kind of what they were going through and just kind of see if they want to do that and then they not. So I was able to gather from that information that my godmother does not want a feeding tube. She never wants that. And that's because she experienced my brother who had one when he had cancer. And also a member of the church who had that, and she just knows she doesn't want that. So I can jot that down as one out of the 10 million things I need to clear off my list. Also tell them what you're planning and just ask for their input. Hey, Mom, hey, Dad, hey, husband, hey, wife. I am trying to gather these things together so we can have these plans put in place for our children or for you or me, so our family knows what our wishes are. Can you help me? Can you shed some insight on what you think your goals and wishes are? And just kind of go from there. So hopefully those tips can help. Those are just a few, but like I said, at the end of the day, you know your family, you know how to come at them or how to talk with them. There's also some more talking points. I think it's on the NIH website. But if you Google how to start the conversation with your loved one about end of life goals, it'll give you a whole list of them. The next point I wanted to talk about is how to decide who to choose for your power of attorney and just kind of what to consider. So of course you want someone you can trust. The person you name as your POA must be someone you can trust and can follow your exact wishes without putting their wishes in the forefront. So someone that they can trust, someone they know that the wishes will be carried out, someone who's very trustful. Someone who has attention to detail, who can act on the patient's or the loved one's behalf about either legal decisions or healthcare decisions, someone who's very responsible, and then also someone who's very available and dependable. We have no idea when things are going to happen. We have no idea when we're going to get sick or there's a life-changing situation, and that particular person needs to be available. They also must understand your responsibilities and just kind of what you want and be able to honor your wishes at any point in time. Now, I wanted to take this particular section and kind of discuss about our patients or loved ones with dementia. So I looked up quite a few things just because dementia is very unique and very delicate, and we want to be able to honor their wishes, and we want to be able to help our families as well just kind of deal with that. So when you're dealing with a patient with dementia, you can always get permission in advance from the person with dementia to have his or her doctor or lawyer talk with the caregiver as needed. Like I said before, the earlier in the diagnoses, the better. You definitely want to get a proxy or someone that can speak on the behalf of the dementia patient, just to get medical records, to be able to talk about it, to be able to get lab work, results, anything like that. For our hospice patients, we require that all of our patients have a primary caregiver, which is someone we can speak to outside of the patient in the instant that the patient is no longer able to speak or make decisions for themselves. Many people are unprepared to deal with the legal and financial consequences of a serious illness such as dementia. So legal experts are encouraged to speak with people who are recently diagnosed with a serious illness, particularly one that is expected to cause decline in mental and physical health. Basic legal and financial documents such as like the will, the living trust, advance directives are available for persons with late or end stage end of life care or financial decisions, and make sure that they're carried out. There are very good reasons to retain a lawyer, and we all can figure that out today. Ms. Paula made it clear for all of us that getting a lawyer to consult or work through those documents and terms and what means this and what means that is very necessary. But there is a good reason to retain a lawyer when preparing for advanced care planning documents. Like the lawyer can help interpret things, talk about different state laws, suggest ways to ensure that the person and family wishes are carried out. And we were able to see that today. At least I know I was. It also talks about like a lawyer is definitely beneficial to help due to the state changes and the person's situation. So it's definitely good to consult a lawyer to make sure you're getting like the best advice and you're using the correct terms to make sure there is a broad spectrum of things or that everything is being covered. So I wanted to break down the dementia stages. And I know I've repeated this several times, but I do want to make it clear. If you were recently diagnosed or had a family member who was recently diagnosed with dementia or a memory loss diagnosis, more recently we're seeing like major neurocognitive disorder due to Alzheimer's or due to dementia or just memory loss, these different little types of dementia underneath, I guess, the dementia umbrella. You want to act as soon as possible to get the power of attorney. you want to act as soon as possible to get it. The mid or late stages, at first, I thought it was too late, but after speaking with Miss Paula, I would say please consult or try to get a consultation with a lawyer to see what needs to be necessary. Just listening to her in the beginning and how she's able to talk with certain patients or certain persons with dementia, even though they may be in mid to late stages, to try to get that conversation started. I would say reach out to a lawyer or Miss Paula for any advice or suggestions on that. You can also reach out to your healthcare team. Some people have home health where they have social workers, palliative care where social workers are there. There's also a thing called a geriatric case manager. I tried to Google that. I didn't find any in this area, but if there is a team, like if you're going to see a neurologist or a nurse practitioner under a neurologist, you may want to see if that particular neurologist has a case manager or a social worker that specializes in dementia and patients with dementia or any other memory loss diagnoses to see if they can help you. We try to encourage and talk about those advanced care plannings, but we usually use our 5 wishes document, the post document, but we really don't go into the legal realm. That's when you would get someone like Miss Paula. And if I'm not mistaken, I think Miss Paula is an elder law attorney, but you would either get Miss Paula or like an elder law attorney to help with older adults and their families, once again, to interpret the laws and plan how the wishes should be carried out. Also to understand any financial options and how to preserve the financial assets. And then, of course, as a social work aspect or as a social work suggestion, I would also say, please talk to the lawyer first about fees before this appointment, and then also see if they all offer, a free consultation to talk about plans and how to move forward. And that's really all I had. I apologize if I talk too fast. I am extremely a fast talker. Does anyone have any questions or concerns regarding what I talked about?
That was great, Karen. Thank you so much. I think that was a great follow-up to Paula and all of the things that we talked about today. I know we're very information heavy, so I so appreciate everybody sticking with us. So I did want to say that Alzheimer's Services, we do a really good job of keeping together lists of local resources. So we have a lot of local elder law attorneys and different legal services locally that I could provide that list for you if you need it. And also physicians and counselors that specialize in the geriatric community or specifically with dementia. I know you had mentioned caseworker. I have some specialized social workers that specialize in dementia and caregivers that care for those with dementia. I have some contacts for some great resources with that. So if anybody needs that list, just email us. I'm so happy to provide those resources for you. Any questions for anybody?
And I do have everything like in a Word document, Brooke. So if anybody, like if I was going too fast and anybody needed just a tip sheet, I can email it to you or however, just to make sure it gets kind of passed out.
Wonderful. Thank you so much.
And I just wanted to make one quick comment. I mean, that was a great presentation, Karen. The 5 wishes, I don't know if anybody's familiar with it. It's not legally binding. I encourage people to look at it, but it is very detailed. And I am an estate planning attorney. I do elder law, and I really like my job. And it actually is kind of uplifting, even though I do deal with, we contemplate unhappy scenarios. But when you have these conversations, there is so much to be gained. Like Karen said, she's learning about her parents. She's learning, having these conversations, get the information while you can. But the 5 wishes is a very detailed program. It's not legally binding, but it's how often do I want my hair cut? What kind of radio and TV do I want to have on? Do I want you to take me to family gatherings? And you don't have to do it, but if you're up for it, if your person is up for it, it's awesome. It's almost something I want to kind of pull out in a discussion I want to have with my family. I don't have any bad diagnoses, but these are things that I want. I mean, man, could you imagine them putting the radio on something you don't want to listen to all the time?
I even think it talks about like songs you want to be played at your services and stuff. It's really detailed, but it's
right. So yeah, I mean, and we may not all have time to drill down for that, but it's a great conversation starter. It can help you get to know your loved one and make sure that your wishes are carried out if something happens to you, and make sure that you're honoring them and giving them the best life that they want. And we didn't go too far into it, but I want you to know that Medicaid planning is available out there. What typically happens is we, Karen mentioned, we spend down the resources, and then the person's actually out of assets, and then we apply. Typically the nursing homes will make that Medicaid application. I want you guys to know that there are attorneys out there and professional planners where it is possible to save some of the assets. So this is not really the appropriate venue to drill down too far in that, but that is a service that I offer. That is a service that other area attorneys offer, where we can reposition assets, move stuff around, to make some transfers, and we can save. If the person's married, we can typically save all of the estate. If they just have children or repositioning, we can usually save about 60%. So you guys, it's not an inexpensive service, but I don't want people to think that just spending down the money is your only option. Again, that's not really the point of this thing, but you may want to consult with an attorney or a planning professional rather than just leaving it up to the nursing home to do your Medicaid application, because they don't do any of those little tricks. They don't do it with an eye towards saving any of the assets. So it's probably worth it to at least consult with a professional. You may want to go ahead with it, you may not, but I don't want you to think that you have to spend every last dime in order for that person to get qualified, because there's typically something that can be done to save assets. And again, the two things, it's getting you qualified, because you can still have your house and go into the nursing home, but when that person passes away, Medicaid has a right to come and take that house back. So there are things that we can do to get them qualified, and then to prevent recovery from that person's estate when they pass. So just not going into detail, but just want y'all to know that that is something that can be done.
That's awesome to know. I like that.
That was a great presentation, Karen, by the way. That was really
Thank you. Same to you as well.
Thanks.
Okay, thank you, Paula and Karen. Brooke had to pop off, so I'm filling in for her. But thank you both for such a wonderful, informative presentation. I think that covered all of the questions that we had. But I think you both did a fantastic job. We're so appreciative of having both of y'all. So thank y'all so much.
Thanks for having me. I appreciate the opportunity.
Thank you so
Absolutely. And I
much.
know Brooke too will be sure to send out a follow-up email this afternoon with the recording and contact information and information from Paula and Karen. So if anybody has any questions, let us know from there.
Okay.
Okay.
Everybody
Thank y'all
have a good
so
afternoon.
much. Bye-bye. We'll see y'all next time.
Thank you.